Supplementary Cause List, item number 1 for pronouncement of judgment.
So I'll read only the operative portion. Having established the fact that material facts and material particulars have been cited in the suit instituted by the respondent plaintiff, the findings of the learned trial court in the impugn order in this regard cannot be faulted. However, this court would agree with the submission of the learned counsel for the petitioner that the observation made at para 28 and 29 of the impugn order, wherein is found the observation or even finding of the learned trial court that there has been encroachment upon the suit property by the petitioner defendant, has substance, inasmuch as in a miscellaneous application, and that too not in the main case, observation of such kind has indeed conveyed the impression that the defendant is already guilty of encroachment, even without evidence being led and appreciated in such respect. Accordingly, while declining to interfere with the impugn order, the observations made at para 28 and 29 of the same, as far as reference to the assertion that there has been encroachment upon the suit property by the defendant petitioner herein, such observations are hereby expunged from the impugn order. To the extent indicated above, this petition is accordingly disposed. Thank you.
My Lord, I'd like to mention, my Lord.
Yes.
Item number 8. On behalf of the respondents, my Lord. My Lord, this is a joint request, my Lord. I have taken the consent of Mr. Nongbri also in this matter.
Would that MECL matter?
Yes, my Lord, 16,000 remaining amount, my Lord, that is.
You have not resolved that issue.
We have already filed an affidavit also that we have followed the procedure, my Lord. That was what happened on the one of the last occasion when this matter was taken up. Lordship is directed.
That is only with regard to the notice.
My Lord, yes, whether we have followed the procedure or not, which was not made part of our affidavit in opposition. So we have done it, my Lord. The procedure was followed, my Lord.
But in any case, is there no possibility of, trying to settle the matter amicably?
Otherwise, my Lord, this matter, if any time the Lok Adalat has been constituted, my Lord, this matter can be put up.
If, just for instance,
My Lord, yes.
if they are supposed to pay 10,000 and they are, allowed to pay only 5 or 6.
My Lord, in that case, if I may suggest, if my friends who's representing the petitioner, why not the respondent and the petitioner sit together, an opportunity will be given. So in that case, they can sit together how to work out this particular amount.
If we refer the matter to Lok Adalat, that will also take time.
My Lord, yes.
But this matter can be sorted out,
In that case, my Lord, I will state no objection, my Lord. It can be done that way.
Necessarily, this matter has travelled for 2 years.
My Lord, yes. Only for that particular penalty amount. That also majority they have already paid. So, my Lord, I have no objection
to that. Also, you see, I have to understand that this is a darbar. See.
And there was an ignorance on their part also, which we are not denying also, my Lord. Which they accepted also.
True. It's not that, yes. It's not that
not deliberate intention, my Lord, yes.
You work it out. Try to advise your client.
Well, I'll speak to the department concerned also. If they're willing, then on the next date, I'll inform Lordship what is the decision of the department, if they're willing to sit together with the petitioners, my Lord.
On premium by the parties, this is matter of 4 weeks.
Right, my Lord.
May it please your Lordship. Lordship, I beg to make a mention of item 2. Lordship. 3 and 4 are connected matters, Lordship.
It goes till 5.
Yes, Lordship. 5 as well.
This Why are you
Lordship, senior conducting
delaying
counsel.
this matter?
Lordship, conducting counsel is having personal difficulty, Lordship.
That is always there.
Lordship.
Conducting counsel means some arrangement has to be made. You are there. Don't belittle yourself.
Lordship.
If there's a matter to be taken up, go through the brief. If your senior colleague's not there, you take it up. Otherwise, only on account of some senior counsel or somebody who's conducting counsel not being present, matter get adjourned from time to time. Had it been, if it is once or twice, okay, understandable. This matter has been adjourned since 2015. On plea made by the petitioner seeking accommodation on the ground that the learned senior counsel who is conducting the matter is indisposed. Matter is adjourned. List the same after 1 week.
Obliged, Lordship. Wait, please, Your Lordship. Lordship, I beg to make a mention of item number 7, Your Lordship. Lordship, I pray if this matter may be listed after 2 weeks, Your Lordship, as the senior conducting counsel is on sanction leave, Your Lordship.
We have been informed, my lord. We have no objection.
On plea made by the respondent, not objected to by petitioner, this is matter after 3 weeks.
Highly obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 6, Your Lordship. I am appearing that this matter be taken after 2 weeks, Your Lordship.
What is required here?
My senior, he need to argue this matter, Your
No,
Lordship.
what is required? I think, I don't know. I don't recall what some affidavit is to be filed.
No, Your Lordship. On the last occasion, my senior has given the submission like he'll obtain the instruction, Your Lordship.
Yes.
Yes, Lordship. We haven't received, Your Lordship, because we have tried calling the client, but that this matter be taken after 2 weeks, Your Lordship.
2017 matter. On plea made by the petitioner, list this matter after 1 week.
2 weeks, Your Lordship. I believe 2 weeks, Your Lordship, may be given.
2 weeks.
Similar prayer for item number 10, Your Lordship.
No objection, my lord.
On plea made by the appellant, list this matter after 3 weeks.
Much obliged, Your Lordship.
Yeah, please, Your Lordship, I beg to mention item number 9, Lordship. Due to
Nine is the
personal difficulties.
only item left in the hearing this. These are criminal appeals. So I don't know why you don't want to pursue. See, criminal appeal means the convict is in jail. If per chance the appeal succeeds, then what will happen? It would be a discrimination to him, having been in custody unnecessarily only on account of counsels asking for adjournment. If he is to remain there, fine, that's not a problem. But if you have come before the court, means you must have some grounds to feel that you are entitled. Anyway, on plea made by the appellant, this is matter after 2 weeks.
Highly obliged, Lordship.
Supplementary course list, item number 2.
This matter relates to challenging the reinstatement of the private respondent. My friend informed me that my colleague is on sanctioned leave.
Respondent number 4, Your Lordship, appearing on behalf of the conducting counsel is on leave, Your Lordship.
But you have to seek instruction to, I think your intention is to withdraw this petition?
No. Regarding that one, the other side raised that it become infructuous. I've seen the file. It is not yet infructuous. What happened is this: we are challenging his reinstatement. And when the matter is kept pending, another complaint crop up, and on that basis, he was suspended again now. And his suspension order he challenged. Lordship upheld it. And matter is pending in division bench. Now, if we withdraw this one, and he is only placed under suspension, at any moment of time, if he is successful in the present inquiry, ongoing inquiry, he will be reinstated. In that matter, our pending writ petition is quite relevant. So at this point up, that was the issue. Therefore, I say that, okay, let me take the instruction from the party and apprise this court. So, in fact, it is not
So there will be no
required for me.
conflict. There will be no conflict or overlapping of those
Yes,
two.
no overlap.
There will be a conflict.
No overlap.
They have sought for suspension removal of the respondent number 4 in the earlier case, and by some luck there was a fresh complaint and he was suspended. Now inquiry is conducted. Now whatever they want to achieve has by, what do I call it,
Per chance.
by chance. Now he is under suspension. Now what survives, Your Lordship? What survives?
Different
See,
petitioner.
as far as the suspension part is concerned,
Right.
you have achieved your objective. But perhaps the issue involved has to be discussed.
Exactly.
But
the issue in this case is whether issue here is whether his reinstatement is correct or not. It is not a suspension. Reinstatement.
Now the same authority which reinstated him, same authority now has
authority
suspended
is same district council. We don't dispute. But the issue involved here today is whether his reinstatement to the same post without giving opportunity to the complainants like me, without furnishing the inquiry report,
I have a
without
suggestion.
allowing them to participate in the inquiry process, is correct or not. That is the issue here. Now another complaint was there.
that is
Yes.
the subsequent complaint has nothing to do with you.
Yes, exactly. It's a different ground, different issue, different allegation is there.
But you see, let's not be impersonal here. We are looking at a person who is occupying a certain position.
Yes.
He is now no longer in that position.
No.
For the
moment, under suspension.
For the time being.
Yes.
So it would seem as if you are flocking a dead horse.
My lord, in that respect, he is no longer sitting in the chair for temporarily. But in case the present ongoing inquiry resulted to his final removal, then this petition also become infructuous. But if he comes back, reinstated again, then here the present complaint, the present procedure adopted by district council, reinstating him without giving opportunity to the petitioner, still remain.
We can also look at it this way, Mr. Sariso. We can look at this as term. You see, the earlier term is over and done with. Fresh term has emerged. Now, in the fresh term, he was subsequently
Course of action. Fresh course of action.
Suspended. So, I don't know why you would revisit the,
I have a suggestion, Your
different
Lordship.
course of action, different issue. The same chair may be
understand,
concerned with,
yeah.
but a different course of action, different issue.
What purpose would we serve? What purpose is your objective is to remove him from office?
My lord, removing, but it is not removed. He is placed under suspension only. Suspension, a person is still in the chair, but not allow him to sit in the chair
Even
because
in
of ongoing inquiry.
Even in the earlier proceedings, he was suspended and then reinstated.
Reinstated. Therefore, Lordship has to examine whether reinstatement is correct or not. That is the issue here.
Understand that?
I have a
So I'm
suggestion.
ready for giving a final argument also. Otherwise, my lord.
I have
Other
a
side also
suggestion,
pray
Your
for the
Lordship.
time.
I have a suggestion. We have to look into the interest of the writ petitioner also. Lordship, this writ petition can be closed, giving them the liberty that they can again come in the event That's what I'm trying to say. That remedy will be open, Your Lordship, for them. It can be closed, but in the event of
If he is reinstated, then.
it's up to them, if so advised.
But he may be reinstated.
Yeah.
No,
He may not be.
He may not be. If he's not reinstated, matter ends there. He'll be facing final removal.
why should we keep
But
this hanging?
if he is reinstated, then this
Yeah,
present petition become relevant again. So in that case, what the special counsel suggested is that liberty given to us. In that case, we will file a fresh writ petition,
That's what I'm
wasting the time of this honorable court. So my prayer is, ongoing inquiry is going on. It may not take long time. So what's harm if the matter is taken up after 1 month?
This case has been kept hanging for too long, Your Lordship.
It's a
Too long.
matter.
There has been made by the learned senior and others to prolong the matter. To prolong the matter on records.
No, I never
Prolong the
said
matter. They
that.
file a missed case for maintainability. After avoiding a lot of time for filing affidavit.
Yes,
then
now
Lordship
I think
consider-
we are only on the issue of maintainability, isn't it?
Maintainability is over, my lord.
Over.
Lordship has decided they prefer appeal against Lordship order, and they withdraw the appeal again and come back here and contesting on merits now.
Oh, now it's on.
On merits. So since my friend was not available, let me come after 3 weeks.
This-
We are ready to address the issue.
If they want, they can argue today also, Your Lordship.
My lord, after my friend is ready.
You are
my-
appealing
You have
for?
come against my
Who's-
order.
Who's respondent for?
No, who is the respondent number 4?
He represents the
suspended
senior,
same.
suspended same, the necessary party. So it's not good for me to press in his absence.
Oh, okay. Yes, he is the person concerned.
My
His
concern. He's
Admitted.
the affected party.
On permit by the parties, this is matter up to 1 month. 4 weeks. No?
Highly obliged.
What is listed for admission hearing?
Admission here.
May be posted for hearing.
It has never been admitted. Right from now. How can it be posted for hearing?
No problem.
Well, it can be finally disposed of in there.
Yes, it
can be
there's no,
disposed,
not
right.
a problem.
Right.
But have you filed your
I had filed my
counter?
affidavit, Your Lordship.
All the respondents are fine.
Reading is completed.
Then we'll maybe listed as the admission hearing.
Let
portion.
it be
Yeah.
for
But it will be heard
final
finally,
hearing,
yes,
Your Lordship. There's no issue.
Thank you. So